Okay, yeah, we are live. There's always that delay, which kind of drives me nuts, but we are live
I
with
can't
our
imagine driving you nuts, Steve.
with our Thursday night live chat with the big man. It's typically on Friday, but he's got stuff going on, so we're doing it Thursday night.
Hey, stuff
So
going on. This is the first time I'm having crawfish this year, my friend.
well,
Uh,
first time what?
having crawfish. You don't have
Oh,
crawfish up
really?
here in Nebraska like we do down here on
No,
the.
we don't have crawfish here. We
Uh,
have to spend a lot of money to get it.
well, right now, or up until recently, it's been a lot of money. The stuff used to be, $4, $5, $6 a pound, and they had a drought in Louisiana, so
Oh,
crawfish come into season here. It was $15 a pound, and no, thank you. I'll go get a ribeye.
yeah, we got a guy that runs a truck down to Louisiana once a week, maybe, and brings it back up here and sells it at a place called Absolutely Fresh. And Steph will go down there every now and then, get some shrimp and stuff. So it's pretty good. It's pretty expensive.
Believe it or not, when I worked on the railroad, we used to go through a little town called Delcom, and they had the shrimp boats there. And on the way back from Abbeville, we would stop at the shrimp boats, and one of us would put all of our stuff in the other's cooler, and we'd walk down to the shrimp boats with our cooler and give them like $10, $20, depending on the size of the cooler,
Oh,
and they would just load you up with shrimp, and we'd take them back and divvy them up, obviously, and but you were getting whole shrimp. They weren't deheaded or anything like that. I mean, you had the short enough real McCoy.
yeah, and that's what she gets from the shop in Omaha is, that they're not deheaded or anything. In fact, they're still probably kind of live. So, yeah,
Well, they're supposed to be, especially with crawfish. You're not supposed to cook the dead ones. You're supposed to cook them alive.
right, right, right. Yeah. Well, this is Nebraska. We're not used to that. So, uh, anyhow, well, hey, I got some questions here, I've got a few that I haven't checked off that I'm sure I've asked you before, but I don't think we've done them on one of our chats yet. So let's go ahead and start with the first one. So just checking the time, make sure we do a half hour of questions here. Do I in Mississippi, do I have to take the field sobriety test?
No, absolutely not. Don't do it. Even if you're a star athlete, don't do it because those are the only people that really have a chance at passing those damn field sobriety tests. What's more is they're going to ask you, do you have any physical impairments that would prevent you from doing these tests? Well, the problem is you don't know what the damn tests are. Who here on YouTube knows what the standardized field sobriety tests are? There's a battery of three of them. And if you know them, leave them in the comments because I'm telling you, you don't know what test you're going to be doing. So you don't know what kind of physical impairments you'd have to keep you from doing it. You may not be able to tell it looking at me on the videos, but I got a lazy eye. If the HGN test, for example, where they finger from side to side, they're looking for equal tracking. I will never, under any circumstances, have equal tracking. And you would not know to say, hey, I have a lazy eye or an astigmatism or anything like that. And I'll tell you a story about the HGN test. Uh, I had a lot going on at one time, and I've always been really good at basic math. Seven times eight's 56, stuff like that. I can just rattle it off. I'm a walking calculator until you start putting triple digit stuff in there most of the time. But I couldn't do basic math. I was having some real issues, and I went to my nurse practitioner right up the road here, and she did the HGN test on me, and I just saw the look in her face of, oh shit. I wasn't equal tracking. So she thought I had some legit neurological issues, and I said, Leslie Ann, I got a lazy eye. You just need to know that. And she grabbed my legs and Joey, you scared me so bad. So you don't know what test you're doing. You don't know if you have the physical impairments. And these tests start in the instruction phase. They don't tell you that, hey, when I tell you to stand in this position while I give you the instructions before you start the test, this is what you need to do on the test. And if you scratch your butt on the walk and turn test, for example, well, you're no longer following instructions. So that they are tagging you all the way. And to a degree, some of these tests are subjective. The one thing I hate is walk and turn test is just such a great example. They'll say walk an imaginary line, and then they may tag you for stepping off the line. Well, hell, they don't know how wide of a line I imagined. I might have imagined a line as big as my waistline, but they don't know that. So, and sometimes you get a good officer that knows what he's doing, and he won't ding you for that. But another one is they start shining a flashlight back and forth and say, that's your line. Well, okay, middle of the night, you just killed any kind of hope of any kind of night vision I might have had, or you shining a light in my eye, then you tell me to walk a line. I'm sitting there going, what? So do not do the field sobriety test. Even if you think you belong on the next all-star team, you pick the sport, don't do it. And on top of that, if you're just a normal human being, damn sure don't do the test.
Now, at the station, does Mississippi still use the intoxilizer?
Yes, right now we have the Intoxilizer 8000. It's my understanding they're supposed to start replacing it with the 9000, but they haven't rolled that out in any jurisdictions that I've had to work in lately. I was actually talking to a prosecutor about it and said, I got to go get some CLEs on this thing because I don't know how 9000 works at all. And he said, you think I do? So nobody knows when it's going to come out, what it's going to do. But right now we're using the 8000. I think there's a couple of states out there that are actually still using the 5000, which is really old. But yes, they still use an intoxilizer at the station. And if you have particularly bad luck, there's some SUVs riding around out there that have an intoxilizer in there. That's actually become less common over the years in my practice. When I first started, I saw that more than I do now. And really, I just asked the question because I used to see it and I haven't seen it in a couple of years. But the station is where they should have the intoxilizer.
Do I have to take that test then at the station?
Now, that's a yes and a no, and it depends all at the same time. I tell people absolutely not, don't do it. And the reason I do that is the second you blow a .08 or greater, and we're assuming this is just a regular DUI, not a zero tolerance for minors, not an 18-wheeler or anything like that. The second you blow that .08, you're presumed impaired. You've got to go show some procedure was violated. You got to go show that the machine wasn't calibrated. And some recent case law on the calibration of the machine really has gone against us. So I tell people don't blow in it. Now, the caveat to that is they're going to have an administrative suspension of your license for 90 days for a regular driver's license. If you hold a commercial driver's license, then it's a full year. Now, also note that if you have a Class D light commercial endorsement, you are still treated as having a regular driver's license as opposed to a commercial driver's license. That's something we worked out at the end of last year with the Department of Public Safety. So the key there is get an attorney involved early because they're going to take your license. They should go suspend your license, but they're also going to send you a notice in the mail that they're suspending your license. And you can hire me to go file a petition to review breath test refusal in a county or a circuit court. And I've been doing this 10 years now, and to date, I haven't lost one. Now, tomorrow, I may go do a BTR and fall flat on my backside, but that hasn't happened so far. And that knocks out the whole refusal part of it, so you don't have to deal with that 90 days. And a lot of times I tell people, unless you have a commercial driver's license, I wouldn't worry about filing a BTR until you receive a notice that they're going to suspend your license, because you're not counting on the license to make your living like a CDL driver. You're not looking at a year suspension. And what's more, Department of Public Safety, they've gotten better, but there was a period in time there to where probably 2/3 or 3/4 of the people never even had their license suspended.
Oh, wow. Wow. Okay, how about if the police officer asks me to get out of my car? Do I have to do that?
Yes, if they have a lawful stop, they can get you out of the car. That's all there is to it. If you got pulled over because your tent was too dark, that officer can get you out of the car at that point in time. They can take you and put you in jail over a tent ticket if they want to. Mississippi Supreme Court's been pretty clear on that. So don't sit there and argue with an officer on the side of the road. You're going to lose. Oh, the youngest attorney, Jake, is having something to say in the background if y'all hear it. But don't get you a failure to comply ticket to go along with a DUI or something like that. Do what they say, hire a lawyer. And one thing I love doing is when I get an officer on the stand and the officer starts asking me questions as the attorney, I say, wait a minute, let me understand this right. We're in the courtroom, right, officer? Yeah. And you're the police officer, yeah. And I'm the attorney, yeah. So this is where I ask the questions and you answer them. So that's the key. Don't You're going to lose on the side of the damn road any which way you cut the pie. Go ahead, follow the commands. You may not agree with the commands. Do it. It's going to be your best bet. And it's a heck of a lot easier to go deal with a DUI that's just losing your license for 120 days as opposed to 6 months in jail and a $500 fine for failure to comply.
Are DUI checkpoints legal?
Yes, they are legal. And they're not DUI checkpoints, though. They are called safety checkpoints or insurance inspection checkpoints or license inspection checkpoints, because that's something everybody should have is a valid driver's license and valid insurance. So that's what they are looking for. That's what they're going to say if they got half a brain when they write their report or whenever they stop you. Now, the second you pull up and you hand them up, what I always do is crack the window and hand it to them. If they say, well, I want your window rolled all the way down, it's like, look, you needed the license and the insurance. You have the license and the insurance. Have you been drinking? I exercise my Fifth Amendment right to remain silent and just move on. And they may pull you out at that point. And do they have probable cause? Unless they can say that I smelled marijuana or I smelled alcohol coming from the car, no, they don't have probable cause. But again, we're not going to argue on the side of the road. That is not the place to go have your trial. Let them write you whatever tickets they want to write you right then and there. Go hire an attorney. An attorney walks in there and says, well, you didn't have probable cause. So whatever you did, it's about to get nixed.
So, what's the difference between a misdemeanor and a felony DUI?
Anytime you're dealing with a misdemeanor or a felony, here's a solid rule of thumb. A misdemeanor the max jail time will be 1 year. And whenever you deal with a felony, it's going to be over 1 year. You can go into the Department of Corrections. On a misdemeanor DUI, on a first, the max is 2 days in jail. On a DUI second, the max jail time is 6 months. You get off into the third and fourth and subsequent offenses. That's when you're getting into the years, and welcome to the felony world.
Do you ever see people trying to represent themselves in court on a DUI?
All the time, all the time. And this is terrible. I like watching it. It's humorous to me, but it hurts my soul. I see them do things on the stand, and I'll be watching in the audience. And there's 2 or 3 times I've caught myself standing up to say objection. And I'm not even in the case. And I have to sit back down. I'm like, be quiet, Joey. And I'll tell you something else. In the state of Mississippi, you are treated as having the same knowledge base as a lawyer the second you decide you want to represent yourself. You're treated like you know the rules of evidence. You are treated like you know the rules of criminal procedure. You are treated like you know the rules of, the statutes, the case law, everything. You're expected to know the decorum of the courtroom, the whole kit and caboodle. It's like you went to law school. And this is a weird example, but have you ever heard of Jack Kevorkian? Dr.
Oh, yeah.
Kevorkian?
Oh, yeah.
Kevorkian won, what was it, 3 trials where they tried getting him for the whole death with dignity thing? Well, his last trial, Jack Kevorkian decided he'd represent himself. And he had trouble getting stuff into evidence because he didn't know the rules of evidence. He didn't know the procedures. He didn't know how to authenticate something. So Jack Kevorkian went to prison. He got to experience a felony level. So don't represent yourself. Go hire an attorney. And I always tell folks, get a good attorney. Ask them a lot of questions. And if an attorney doesn't walk through everything with you, don't hire that attorney. There's a lot of attorneys out there. You want to get one that's going to do do you a solid. And no attorney's going to sit there and guarantee you a win. I tell folks, if you got an attorney guaranteeing you a win, I guarantee you that's the attorney you need to get away from, or at the very least, get them to sign something saying that they guarantee it and sue them when it goes south.
So we talked a little bit about this previously in this chat, but how does a DUI arrest impact my driving privileges?
If it is a DUI first offense, you're going to lose your license for 120 days. If it's a DUI second offense, you're going to lose your license for a year. And all that supposing that you have a regular driver's license. Once you get into the CDL world, you're going to lose your license for a year on a DUI first. And by the time you get to a DUI second, the Code of Federal Regulations is going to start tagging you, and Mississippi mirrors that, and you're about to lose those CDLs permanently because that's two major events is the way they look at it.
How about folks with professional license like a doctor or lawyer or teacher?
So a doctor or a lawyer, oddly enough, probably won't be as impacted as some other professions out there. Nurses really get hit. Doctors will get hit harder than lawyers, much harder. And the reason is they have that whole DEA authorization to go write meds. And they figure if you have this problem out here, then you must have another problem going on. So you end up having to jump through all kind of these loopholes and not loopholes, hoops. And you also got to look at the contract that you signed. A lot of them have a morality clause. They may say something about drugs or alcohol and what you agree to do. Lawyers may have that at a law firm, and they actually have the LJAP program here in Mississippi, Lawyers and Judges Assistance Program. So if you are a habitual user of something or you are having a problem, it's sort of a program that they put you on. Excuse me, dinner was good tonight. It's a program they put you on as a professional that ensures that you don't have a relapse or anything like that. But that's an elective thing, generally speaking. Teachers, I haven't come across any teachers that had their licenses impacted. Nurses are the big ones I deal with because, again, they're getting the same thing that doctors are in. And I don't know if you ever saw the show Nurse Jackie. I mean, Nurse Jackie had some problems. So they start looking down that path. But those are the big ones that I can think of right off the top of my head.
Well, stepping down just a little bit here on the charge of DUI first, do most of those, at least the ones you handle, do they go to non-adjudication? I know that's a really good thing, and you should probably explain what non-adjudication is as well.
Right. The answer to your question is it depends. Non-adjudication is a program, and the process goes something like this. You technically stand in front of a judge and say, Judge, I'm guilty of a DUI first offense. And then you petition the court for non-adjudication to enter the program. And in that program, if you have a DUI alcohol, then you can either take a 120-day license suspension, or you can go get an interlock device installed in your automobile and keep it there for 120 days and drive your car and get an interlock restricted license, all that good stuff. You can pay the fine. You pay the $250 non-adjudication fee. Most courts will put you on either supervised or unsupervised probation. In Central Mississippi, they use Court Watch. You get over into, I think it's Eastern Mississippi, it's TAME. They have all these different programs that cover different regions. They all got a little different name, and that's who you do it through. And a lot of times you go through an alcohol and drug assessment. And if it was a one-off deal that you had 2 glasses of wine with your steak dinner, and that was the only thing that you do, and you drink once a month, then they're going to say, okay, this person isn't a habitual user. They don't have a problem. This is a one-off event. But if you've got somebody that's having withdrawals while they're at the meeting, then they're going to say, okay, you got some issues. We need to get you in a program, and you'd have to follow the rules of that program. And you can't get any other charges, any type of charges. I tell folks, don't even get a seatbelt ticket. It's not worth it risking all that, because remember, you've entered a plea of guilty And the judge is taking your guilty plea and putting it up on the corner of his desk in a pile with other non-adjudications, waiting for you to complete all the terms and conditions. And I told you it's normally 6 months supervised or unsupervised probation. Keep in mind, courts down here have jurisdiction for up to 2 years. There's one judge I know of who keeps these things for 18 months. By far and large, 6 months is how long the court's going to keep it. You jump through all those hoops. Oh, one other thing I need to add. If you had a drug DUI, marijuana, for example, then instead of having an interlock device put in your car for 120 days, you go take 4 months of drug test. Just go to a local walk-in clinic, give it to me, give it to the court, give it to Court Watch, whoever you need to give it to. And once you've completed everything, the judge will sign a final order of non-adjudication, and that never hits your record. So that's a really good thing, because then you can turn around and expunge the arrest and everything the next day. But I wouldn't say that the majority of my cases are non-adjudications, because if you've had a prior DUI, even if you've had non-adjudication before, if you've had it expunged, you don't qualify for non-adjudication. The only people that will have a record of this non-adjudication, ultimately, if you expunged it and everything, would be the Department of Public Safety. They keep it in a vault down there. And the second you try doing non-adjudication again, you're going to flag. And what's more, when you do non-adjudication, you just sign something under oath saying, I've never had a prior non-adjudication. So you've just added perjury onto your DUI potentially. So that's something to keep in mind. And if you got a CDL, you don't qualify. I cannot stress that enough. So many folks come to me wanting non-adjudication. They got a CDL, and I tell them, you don't qualify. They go hire some schmuck down the road that charges half of what I charge, and they go in there and non-adjudicate. It gets kicked back by the Department of Public Safety, and then they're stuck with this DUI, and they come to me on the appeal to fix it. And they're like, I can't believe this happened. Well, I told you it would happen in the consultation. So if you have a CDL and a lawyer is trying to non-adjudicate your case, go get a different lawyer.
Okay, so let's say it's a DUI first, and you get the discovery and you see all kinds of things in there. You know, the cops made mistakes or whatever. You look at it and say, I'm pretty sure I can get this guy off. I know he can't guarantee anything, but you feel good about it. Then and I know it's ultimately up to the client, but would that be a real strong case then to go to trial as opposed to non-adjudication?
Yeah. Yeah. I've showed up in a municipal court before where I had 2 cases, and they started filling out non-adjudication paperwork as soon as they called the docket. And I said, we want a trial. And everybody looked around, and the judge slid the paperwork over, and they dismissed that DUI. And he just grabbed his non-adjudication paperwork and started filling it out for my next case. I said, Judge, I want a trial on this one too. We got that one dismissed. And,
Yeah. Oh, absolutely.
So
Absolutely.
I tell clients right before trial, after I've looked at the discovery and everything, I call them up. I tell them the good, the bad, and the ugly about their case, because every case has it. There's no ifs, no ands, no buts. And there are some clients I tell them this is a good case to go try. Non-adjudication is hard to tell you absolutely a hard no on, but once in a while it's worth it for a client. But I also tell them that if you try this, it's win big, lose big, and it's your call. And I don't have a problem trying a case, none in the world. And there are some people that have taken non-adjudication that I thought they had a good case that I wanted to go try, but they weren't willing to take the risk. And once in a while, I have a client that's willing to take a risk with me. And when I tell them that, it usually pays off because I see a gaping hole to walk through, but I have to advise them of both sides of everything so that they're fully apprised and they're making an informed and educated decision. It's people think I hired a lawyer, the lawyer just fixes it all. No, the lawyer tells you your options and how he thinks he can get to the goal line. It's your decision whether we want to punt, we want to kick a field goal, or we want to go for the touchdown. You tell me which one of those you want, and that's the mark I try to achieve. And I keep you informed all the way. If it looks like, we got some bad evidence to come up, we're not going to make a touchdown here, but I bet we can get us a field goal. What's the client's option? Do we throw a Hail Mary and go for the end zone, or do we kick the sure enough field goal?
Marijuana DUI, for the cop to have probable cause, don't they almost have to smell marijuana in the car or see a bag of pot on the passenger seat or something?
You got it, Steve. That's exactly what it is. And a problem that users, what's interesting about marijuana is there's been so few tests done in the U.S. Uh, they've almost all been done overseas, the Netherlands, and it's Mary. Oh, I'm drawing a blank on her last name. She's the premier marijuana uh, expert scientist in the U.S. So we're just now getting some reliable data in the last couple of years on marijuana. A problem with folks that use marijuana is their olfactory senses are shot. They don't smell the weed in the car. And we've all been walking down the street and pass somebody, and it's like that some gun is a little bit on the loud side of life. Uh, so once the officer smells it, he's got probable cause to go from there. And what happens? People want to talk naturally. I'm on here talking with y'all for half an hour. You're on here listening more than you're talking, but we'll get to trains and it'll swap. So then they start admitting to, yeah, I smoked a little bit before I left the house, or they'll see a roach there in the ashtray, and they'll have red bloodshot eyes. You're not going to have many DRE, drug recognition expert certified officers out there. What's more, you're not going to have the controlled environment to do a DRE test on. You're not going to do a DRE examination on the side of the road. That's going to be in a very, very controlled environment by a very, very highly trained individual. And you just don't see that a lot. But it's the totality of the circumstances they start looking at. Well, I smelled weed. He admitted to it, and there's a blunt in the ashtray that's still smoldering. Well, you're about to get a marijuana DUI, and they're going to ask you to pee in a cup or draw your blood after that. The problem there is, one, our crime lab is so backed up that it is stupid. And you have a Sixth Amendment right to confront your accuser, which would be the person performing the test. You look at Bull Cummings v. New Mexico, and that's the test that said that the individual the scientist that performs that test is now your accuser. They're not going to be there in Mississippi because they're so backed up. So that's a real strong argument that you have on those cases. And does a refusal become worth it at that point? I don't know. If I was looking at having to pee in a cup, I might consider that because the state's going to have trouble getting that evidence in because they're not going to have the forensic analysis. It's not like the intoxilizer. The intoxilizer should print out a form called an IPO1E. And if that form's printed out, our Supreme Court said that proves calibration. Well, that's not how it is with a marijuana or any other substance DUI. So you have a lot more maneuver room from a scientific to legal perspective. Now, realistically, go back, Mary Huestis, that's who I was trying to remember. Most people don't know her research. They're not familiar with marijuana DUIs, how marijuana interacts with the body, how smoked marijuana versus marijuana that's consumed via edibles reacts with the body. So these judges don't necessarily understand it. And for a while there, they were damn near just rubber stamping marijuana DUIs simply because they didn't know what to do.
Any interesting cases this week?
This week has actually been a really calm week for me. I was in Oxford this week, but that was just for a settlement conference on a workers' comp case. This has kind of been a workers' comp kind of week, and I've had all those road weeks going on. So I can't complain too much about a desk week. We really needed it to catch up on some of my paperwork. You can only answer so many phone calls from the road because people want to ask you all these complicated questions and you haven't looked at the specifics of their file, or you don't have it pulled up in front of you. So you can't answer that from the road. I've done enough DUI work at this point that I can do a consult like it's nothing. And a consult on the comp side I can do from the road. But when people want to start talking about the evidence and the discovery, unless I have it in front of me, I can't talk intelligently about it. So I'm sorry to pop your bubble on that, Steve. I've had some good consults that were interesting to me, and but that's about it. This is a really messed up situation. There was a case from Madison County where I live, actually, which is just north of Jackson. You have Hinds County down here, which is the seat of government for the state of Mississippi. And just north of it, you have Madison County. In 2017, there was these 2 or 3 kids, I think 2, that were going to carjack a vehicle from Kroger parking lot in Jackson. And they get to going down the road, and lo and behold, they discover there's a 6-year-old in the car. And they don't throw the kid out at a fire station or something like that. No, they shoot the kid, and they drive off and leave him in the car. And they get arrested subsequently. But one guy obviously committed capital murder, and that's been handled. But this March, and I just saw the opinion because I was researching accessory after the fact for somebody this week. And there's a really good opinion that come down on that. The poor kid, it's hard to feel bad for him, but anybody who's 18 years old going to prison, you can't exactly celebrate that either. That's a whole different video in of itself. But the Supreme Court said, you got to remember this first guy, he got tagged for capital murder and carjacking. Well, this guy got accessory after the fact for murder, kidnapping, and carjacking. And they said that since it was 3 separate felonies, then he gets 3 separate accessory after the facts. The dissenting opinion actually held that the kidnapping and murder should have merged capital murder like it did over here. And he should have had a capital murder one, and he should have had a carjacking accessory after the fact. So research was interesting to me this week. I know that's a little bit of a morbid topic, but the intricacies of the law, when I come across something like that, always fascinates me. There's one justice here at the Supreme Court. I love the man to death. I think he writes wonderful opinions. Unfortunately for me, as a criminal defense attorney, he's the dissenting opinion almost all the time.
Oh, wow. Well, hey, Joey, this has been great. Another live chat with Attorney Joey Franks, the big man at Big Man Law in Jackson, Mississippi. Have a good evening.
Will do, man. Folks can try subscribing to us. We're trying to be regular about these Friday things, but we keep screwing it up. I think you went to Kansas on me the other week, and I've got a meeting tomorrow night over crawfish. And when you combine business and pleasure, that's always perfect. Like it, leave us questions in the comments. If you got something you want to see, something you want us to talk about, we're glad to do it. We're mostly just having fun on here. And subscribe, get the notifications.
It's important to hit the bell icon so you know when there's a new video.
Ring the bell, huh?
Yeah, ring the bell. Hit the bell.
Steve,
all right.
I appreciate it as always,
yeah,
man.
Yeah, same here, Joey. No, that's not what I want to do.